Hey Law Nerds, this is Professor Tracy here with a lecture regarding negotiable instruments. This lecture is an introduction to what is a negotiable instrument and what function do they serve and what makes something negotiable or not negotiable. So let's get right to it. So the first question we have to ask is, why do these things exist at all? Why do we have negotiable instruments? What problem were they solving? There's really two problems that were being solved. Is one, often people either in fact do not have enough money or feel like they do not have enough money. And the other problem is that when we start talking about large quantities of money, that money becomes awkward to carry around and unsafe, right? It's unsafe to carry around large wads of cash or wheelbarrows full of cash. So these instruments came about in order to solve both of these problems. And so we'll see why that is. When we talk about not enough money, here we have Bob. He's writing out this note. It says, I promised to pay $10,000 to the order of Herman on December 23rd, 2022, Bob. So there, Bob has written out what we call a promissory note, which is evidence that he's promising to pay Herman an amount of money, right? So that note represents that obligation that Bob has to pay Herman that $10,000. And often we sign promissory notes because we have been given money, right? We've been given a loan. And so that solves that problem of not having enough money, that somebody's willing to give us a loan. I'm willing to sign a promissory note, giving them this note that represents my obligation, my commitment to pay them $10,000. And often in the real world, that would include a promise to pay some amount of interest on top of the principal there. So the other issue we said is that if you need to make large purchases or you have a lot of money, having to store that or carry it around is awkward and unsafe. And so we have developed the idea of depositing your money into a bank and then using that money through the use of things like checks or debit cards, which function similarly to a check, right? So here our focus is on these checks that we call a check. It's a draft, so there are two categories then of negotiable instruments. There are notes and there are drafts, and a check is a type of draft. So here, important to understand that Bob is giving this check to Herman, right, as payment, right, as payment as part of a transaction, a commercial transaction, as part of a contract. And we'll see that more specifically in an example we're going to look at in a second. So the two types then of negotiable instruments, as we said, are notes, promissory notes, and drafts, of which checks are only one species. So when we talk about a note, what is distinctive about a note is that it is considered to have a promise to pay. A note has a promise to pay, right? It contains the promise to pay. And when we have a promissory note, we can identify the parties. There is the maker of the promissory note, of the note, which in this case is Bob, right? The person who is making out the promissory note and giving the promise, making the commitment to pay the money. Then there is the person to whom that obligation is made. The party to whom that commitment is made is called the payee. The payee, in this case, it would be Herman. When we look at a draft, we said that one type of draft, and by far the most common type of draft, is a check. And so when we're looking at this, what's distinctive here is it contains an order to pay. Notice what's going on here is that the check is an order from Bob to the bank to pay money to Herman, right? It's an order or a command that Bob is giving to the bank to pay money out of his account to Herman. So what makes it a draft is that it contains that order to pay. And when we have a draft, there's the person who is called the drawer. They're the ones drawing on their account. That would be Bob, right? He's the drawer. He deposited his money in the bank. He's now drawing on that money by a check. Then there's the drawee, which is the bank that is holding that money, right? That is holding that money. A draft is a check if the drawee is a bank. If the drawee is something other than a financial institution like a bank, then it is not a check, as it's some other kind of draft. It could still be a draft, but it is not considered a check. And the payee would be the final party of a draft, which is the person to whom Bob is directing the bank to make payment. Here would be Herman, right? He is the payee. So we saw with a note has just two parties. A draft has three parties. So what makes something, so we've got our two instruments, right? We've got our checks, our drafts, and we've got our notes. And those are the instruments that we're looking at. But what makes an instrument negotiable versus non-negotiable? What do we mean that something is negotiable? To talk about negotiability, simply put, it means that the note or the draft is freely transferable and collectible, independent of the underlying transaction from which it sprang. Meaning that the note or the draft can be transferred to other parties, and it is able to be transferred and collected on regardless of the fact that there might have been an underlying transaction, a contract from which it sprang, and regardless of how that transaction unfolded, that instrument would be freely transferable and collectible independent of that underlying transaction. So let's look at an example. Suppose we have Barb and Bob. They have an underlying transaction where Bob is promising to pay Barb $10,000, and in return, she is promising to deliver to him her Honda Fit. Okay, so we have a very simple contract, right? A very simple contract. It's the underlying transaction here. Let's say that the next step is that Bob makes out a note to Barb that evidences this promise to pay $10,000, right? That's what the underlying contract said, is that he was committing to pay $10,000. And so he writes out a promissory note to Barb to that effect and gives it to her. So now she is the holder of this note from Bob, which contains a promise, right? That's what a note has to have. It's a promise to pay $10,000. The maker of that note is Bob. The payee of that note is Barb. And then, so that's where we are at the end of 2, right? Is that Barb has this note, and understand, as we just said, that note is made in recognition of that underlying promise that Bob made in the contract to pay $10,000. And here, what happens if Barb is going to try to sell this note or transfer the note to the bank? And for value, right? That the bank has money, it's willing to buy it from Barb. And typically when a financial institution or even an individual investor is wanting to buy something like a note, it's going to pay for it less than is promised in the note, right? Otherwise it wouldn't make sense, right? Why would you pay either the same amount or why would you pay more? You certainly wouldn't want to pay more. Normally you would pay less, and the advantage to Barb would be that she gets money now as opposed to having to wait for Bob to pay or maybe not pay, depending on how much of a risk there is there. And she gets that money now, and then the bank is now holding this note ostensibly expecting to be eventually paid by Bob, right, to receive this $10,000, to make money on whatever it spent. If say it bought the note from Barb for $8,000, then it would make $2,000 when Bob paid on it. So here, if we have this exchange of them buying it for money from Barb, and one of the things I want you to understand is that this giving of the note to the bank under contract law, that would be considered an assignment. It's an assignment of contract rights. So understand what the note represents. If we go back up to this underlying contract, right? And if Bob and Barb entered into this contract and we're thinking about, well, what rights do each of these parties have? Then the answer is this, right? That Barb has a right under the contract to receive $10,000. And Bob has a right to receive a Honda Fit, right? So we're assuming that this is a legally enforceable contract which creates in the parties contract rights, right? Contract rights. And we know that when those rights, if I'm selling them to someone or giving them to somebody, that is an assignment of contract rights, an assignment of contract rights. And because the note represents this obligation, it is representative of the right that Barb has to this $10,000, right? It's like a tangible manifestation of her right to this $10,000 payment from Bob. So when she sells that note, she is in essence assigning her right to payment to the bank. And in this case, she's assigning it for value, for money, for consideration. And so let's continue the story. Note that this was number 3. We're popping on to the continuation of the story on the next slide here. And let's assume here with number 4, our fourth part of the story here is that after the bank buys this promissory note from Barb, that Barb breaches the contract, that she does not deliver the Honda Fit. Now we know that is very, very likely to be a material breach, which would mean that Bob would be excused. Under contract law, Bob would be excused from having to pay his $10,000 because Barb never delivered the Honda Fit. She breached, right? She breached in that regard. And so Bob would be free to not follow through on his obligation, his duty to pay the $10,000. So the question we have to ask is, if we remember that the bank is the one that's now holding, right? If we go back here, the bank's the one holding the note, right? Holding the note. And the question is, well, what if after Barb breaches, what if they then present this note, right? We said that's a breach of contract there. But what if the bank now in step 5 in our story says, we want you, Bob, to pay? The question we have to ask is, well, can Bob point back to the underlying contract and say, well, Barb breached, right? Barb breached. I don't have to pay you, and you shouldn't have any greater rights than what Barb had. If this is an assignment of rights, then you only have the rights that Barb had. So if we're asking this question of, well, can they do this? Can they insist? Can the bank insist that Bob make good on this promissory note that he gave to Barb and that the bank bought from Barb? Can they insist that he pay despite the fact that Barb breached on the underlying agreement? Under contract law, the answer is no, right? Because we know that we said it was an assignment. And if you're the assignee of somebody's contract rights, you have no greater rights than they have. So under straight up contract law, first year contract law, then they would have no greater rights. Could they present this and expect Bob to pay? No, because he could assert that Barb materially breached the agreement and that he is therefore excused from having to perform. This is where this course picks up, though, because that situation that we're zeroing in on shows you the potential problem. If that was the case, if every time a financial institution bought a note, or every time a check was being transferred between financial institutions, if every time that occurred, they had to be concerned about the underlying transaction, about whether the parties performed as they were supposed to, about whether or not the agreement was subject to some sort of defense. If those kinds of things were true, then you would never have negotiability, right? Why would anybody want to keep buying these kinds of notes or taking checks from other financial institutions? Why would that occur if it was always tied to what occurred in the underlying transaction? We know that under straight contract law, the answer is you're out of luck. It's an assignment. That bank, that assignee of this right to payment has no greater rights than those than what Barb had, right? Barb can't insist on payment after she's breached, and the bank couldn't either under contract law. But under UCC Article 3, which is what negotiable instruments is all about, the answer is maybe, right? Maybe. I know you were thinking the answer would probably be yes, but the answer is maybe, because there has to be a number of things that are true, both about the nature and the form of that note, whether it's properly considered negotiable, and we'll see whether the bank is what's called a holder in due course. So we need these two things, right? That the note itself, this note that Barb sold to the bank, that note must in fact be negotiable. For it to fall under UCC Article 3, it would need to be negotiable. And the bank must qualify as what's called a holder in due course, or an HIDC, a holder in due course. Because if it's not negotiable, then you can't transfer it, right? And if the person, even if it is negotiable, if the bank is not what's called a holder in due course, then they don't take that free of any sort of defenses or concerns about the underlying transaction. So both of these things need to be true. Our focus in this lesson is really the first. I'm gonna briefly talk about number 2, about a holder in due course, but that is gonna be our focus down the road on probably like 2 lessons from now. But our focus right now is on the first. So, but let's briefly look at, well, what do we mean by negotiable? And in just a second, we'll look at each of these requirements in detail. So we're looking at UCC section 3104, where it says, here are the requirements, right? Here's what makes an instrument negotiable. We said we have 2 kinds of instruments we're focused in on, notes and drafts. What is it that makes them negotiable? There's a laundry list of things. Those are, it's got to be in writing. It must be signed. It must contain an unconditional promise or order, and it must be that promise or order is about a fixed amount of money, right? A promise to pay a fixed amount of money, or an order to have the drawee bank, for instance, pay a fixed amount of money. And there's this idea of a courier without luggage, meaning that the instrument can't contain extraneous terms or promises other than the promise or the order to pay the fixed amount of money. And it must be payable, that amount of money must be payable either on demand or at a definite or fixed time. And it has to be payable to the bearer, meaning the person who's holding the instrument or bearing it, presenting it to be paid, or to order. And we're going to unpack all of these in detail in just a second. But all of these things, each and every one of these requirements must be met in order for us to say that an instrument, that a note or a draft is negotiable. And then, as I said, we're going to look at number 2 here in more detail in some future lessons. But what we mean by a holder in due course, if you were to put it simply, it's talking about, is the person holding the instrument in good faith and basically without knowledge. So you'll see these requirements here. Don't get hung up on them now, because we're going to look at them in great detail a little while from now. But they need to be the holder of the instrument, and so meaning of the note or of the draft. They must have bought it or given value for the instrument, right? It's not a gift. It's not gratuitous. They gave value for that instrument. And they have no notice of any claim against, that would relate to that instrument, or any defense to its collection of payment, or any suspicious facts surrounding the instrument and its making. Nothing that would tip them off that maybe this thing isn't what it looks like it is, and maybe it may not actually get paid. So, and that they took it in good faith. They themselves took it under circumstances that were not suspicious, not done in a nefarious way or with any sort of underhanded dealing, that they took it in good faith and with an understanding of, I believe this represents what it is, and I have no notice of any claim, defense, or suspicious facts, etc. If all of those things are true, all 4, then that party could be a holder in due course. So we'll look at that in future lessons. So what is it we said we're going to look at these details, and the focus of this lesson is on what is it that makes something negotiable. And we looked at all of these requirements. So let's look at each one in detail. It's got to be in writing. That's pretty straightforward, that it must be a written instrument as opposed to an oral instrument, because if it was oral, how is it that there's no way to transfer something that's just spoken word, right? It's got to be something that is recorded, that's written down in some way. It doesn't necessarily have to be on paper. So if you look at a case like Good versus Wells Fargo, then it can be an electronic note, for instance. There are federal statutes now that talk about what it means to be a holder of a electronic promissory note, but it is in fact possible to have a negotiable instrument like a promissory note or some sort of draft that's electronic in form, assuming you follow all of the governing statutes. So it's got to be signed. When we talk about something needing to be signed, like one of these instruments, we're going to look at, well, what counts as a signature? Where does it need to be signed? Location. And then what if you're not signing somebody's personal name, but they're signing, say, the name of their corporation or the trade name of their company, as opposed to their name, if, say they're the president of the company or something like that. What counts as a signature? When we're thinking about it, it's any symbol that is being executed or adopted with what the code says is a present intention to authenticate. A present intention to authenticate, meaning saying, this is mine, right? I'm authenticating this document. I'm adopting it. And that symbol, if you look in detail at what how signature is defined under the UCC, it can be something that's printed, it could be stamped on there, it could be written, it could be something, your initials, it could be a thumbprint, it could be any other kind of symbol, right? Like if you're the artist formerly known as Prince, whatever it may be, if that is being used by you, you've adopted it as a way to authenticate, to say this, I am intending to authenticate this document and saying I am adopting it, it's mine, then that works regardless of what it looks like and how it was produced. What about the location? It doesn't matter where on the document, the note or the draft, it's signed. You can be signed anywhere, and indeed we'll see moving forward that is quote unquote signature can be found even in places like maybe in letterhead on some sort of letter or something like that, as a way, as long as it was intended to authenticate at the time it was used. And the use of trade names is fine, again, assuming, again, the trade name is being used because there's an intent to authenticate, to adopt, or accept that instrument when it's being written on there. Then that's fine. So what about, it's got to be, so not only does the note or the draft have to be in writing, it has to be signed. When we say signed, typically what we mean by that is if it's a note, it's signed by the maker of that note. If it's the draft, or again, it would be signed by the person, by the maker, right? By the person who is writing out the check, right? They're the ones who must have signed it. And we said that it's got to have an unconditional promise or order. If we're talking about a note, then we've already said what makes something a note is it has a promise to pay. So it must have an unconditional promise to pay. If it's a draft, it has to have an unconditional order to pay. So if we're looking here back in our fact pattern toward the very beginning here, where we had the underlying transaction, and then Bob wrote out a note, gave it to Barb, and there we said there would be this question. Does it contain an unconditional promise to pay, right? It's got to be in writing, it's got to be signed, and it's got to contain an unconditional promise to pay. So if it said something like, I promise to pay $10,000 to the order of Barb only if the car passes inspection. That is not unconditional, right? It has a condition on it, which is that only if the car passes inspection. And that condition is expressed, meaning it is laid out in the terms, the language of the note itself. That kind of thing means it's not a negotiable instrument, right? Now keep in mind, all we're asking right now is it negotiable? It still could be valid evidence of the obligation to pay. It's a separate question of, does it fall under UCC Article 3 as a negotiable instrument? That's what we're asking when we're saying, does it meet all these criteria? Not, could it represent a valid promise by Bob to pay? Sure, it could even here, right? But it cannot be negotiable under Article 3 if it contains a condition. It's got to be an unconditional promise to pay. So this doesn't work. So what about this? December 7th, 2022. I have this day purchased a 2012 gunmetal gray Honda Fit from Barb, and I promise to pay $10,000 to the order of Barb. So what about that? Here, that's fine. What you want to realize is, okay, isn't it hypothetically, doesn't that mean the note is indicating or giving notice of an underlying transaction, which isn't that sort of suggesting that, well, what if this transaction doesn't go through smoothly? Or what if one of them breaches? Or what if there's a defense? So isn't it actually conditional because Bob is saying, I have this day purchased a 2012 gunmetal gray Honda Fit from Barb, and I promise to pay $10,000 to the order of Barb? Well, there, the answer is no, it's still an unconditional promise to pay. The recognition that there's an underlying transaction doesn't turn it into a conditional promise, right? It doesn't turn it into a conditional promise. Any condition there would be implied or implicit. And so that doesn't defeat negotiability. It's still negotiable. It's got to be for a fixed amount of money, And we need to be careful of this. So keep in mind, what we're asking is this instrument negotiable? Does it fall under UCC Article 3? So is it in writing? Is it signed? If it's a draft, does it contain an unconditional order to pay? If it's a note, does it contain an unconditional promise to pay? And is it a promise to pay a fixed amount of money or an order to pay a fixed amount of money? What do we mean by fixed? So one is just the straight up, it's got to be money. It can't be some other sort of monetary obligation, other sort of obligation like this. I promise to mow the lawn of the bearer of this instrument. That's not going to work, right? Because that's not for money. It has nothing. It's about mowing the lawn, right? It's like your kid gives you a voucher for Christmas to have you mow the lawn or whatever. So it has to be readily calculable from the face of the instrument. From the face of the instrument. So we've got to be able to know what the money is, what is owed from the face of the instrument. We can't, and well, there's some exceptions to that, so to speak, but what we mean is it can't be like this. I promise to pay the bearer of this instrument half the proceeds from the sale of my lawn business. So think about this. We have no way of knowing from the face of that instrument what half the proceeds from the sale of his lawn business are, right? We have no way of knowing that. And so that's not readily calculable, right? That's not the kind of thing we can go, oh, we can figure out how much money is owed on this instrument. So if this gets transferred to all kinds of different people down the road, this would be no problem to figure out how much is ultimately going to be paid on it. The answer is no, it would be impossible to tell from the face of the instrument itself. And so this kind of thing is problematic in terms of negotiability and making it fall under Article 3. So what it may, and this is what I was getting at, we're saying there's quote unquote maybe some exceptions you could say to readily calculable from the face of the instrument, which is it may include fixed or variable interest, right? So you could have some sort of interest calculation that's required. That's still considered a fixed amount of money under Article 3. It specifically says under the code that having fixed or variable interest is fine. And so if it says this, I promise to pay the bearer of this instrument $10,000 plus interest at the prime rate on January 1 at the beginning of the year, with principal due January 1, 2024. Bob. So there you can look at this and there's interest, but we can figure it out, right? And it's variable, right? Because it's whatever the rate is then. We didn't set it when it was signed, when Bob wrote out the promissory note. It's whatever the rate is on that particular day. That's what it's going to be, right? So it's variable in that sense, and then fixed once we know it as of that date. But so that's where we would put it, right? That's fine. This is fine. That works. It still works. What about this courier without luggage? And I already said that means there's no extraneous terms or promises. So what we're saying is an instrument is not negotiable. And here's what the code says. If it states what? Any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money, right? It's got to contain just the promise or the order of paying the money, the fixed amount of money. That's it. Nothing else. And so what about this? I promise to pay on demand $15,000 to the bank. Furthermore, I promise to seek all my future business loans from the bank or the holder of this note, Bob. So that doesn't work, right? Because it's got this furthermore additional promises in there that mean, no, it's freighted with other kinds of obligations. So that doesn't work. There are exceptions. It can contain a promise to put up collateral. That's okay if that's in the note or the instrument. It could have a promise to what's called confess judgment, which is a way of saying, I'm saying if I, the maker of this note, breach, right? If I default, then I am surrendering or agreeing to whatever legal judgment it needs to be entered against me, right? Because of my default, I'm confessing judgment or surrendering or whatever you want to call it. That's a common thing to include on a note, and it's fine. That kind of promise, so a promise to have collateral, a promise to confess judgment, those are fine, even though they're quote unquote in addition to the promise or the order to pay money. So, and you can have a promise to waive certain legal protections, right? If there's certain legal laws that provide you protection, it could be things like I agree that this body of law will govern. I agree to arbitrate. I agree to waive these protections under this consumer protection law, assuming they can be waivable. You would be able to waive those kinds of protections. It has to be payable on demand or at a definite time. So what do we mean by that? If it's on demand, what we mean is that's payable at the will of the holder, meaning that it's payable at the will of the person or the party, who is now holding the instrument, right? It could still be in the hands of the person to whom it was originally given, but if it's payable on demand, it means it's payable whenever that person holding it demands payment, right? So there's no fixed time. It's whenever they demand payment. So payable at a definite time is what it sounds like, right? That it's payable could be after a set amount of time, like you have 6 months, you have 5 years, you have 30 years, or it could be on a specific date, right? On a specific date. So let's look at a bunch of examples in this regard. So Bob says, I promise to pay the bearer of this instrument $10,000. I will pay upon being asked. So that kind of language, I will pay upon being asked, that's on demand, right? Saying, I will pay upon being asked. That's I will pay when you make the demand, when you ask for payment, that's on demand. What about, I promise to pay the bearer of this instrument $10,000, payable June 1, 2023, Bob. That's payable at a definite time, right? Pretty straightforward. So what about this? I promise to pay the bearer of this instrument $10,000. Here, it doesn't give a date. It doesn't say, I'll pay when you ask. It doesn't say payable on demand. It doesn't say that, but what the code tells us is in the absence, when there's silence like this, it's payable on demand, right? So that's fine. The fact that it's silent, that's fine. It just means it's payable on demand. So 4 says, I promise to pay the bearer of this instrument $10,000. Payable June 1, 2023, but the holder may extend the date of payment in the holder's discretion, Bob. So this is also okay. This is okay because why? It gives us a specific date, right? So it's payable at a particular time, and then the current holder, it gives the current holder of the note, the ability to extend the date of payment, to show grace to Bob if it wants to. And that's fine because the person currently holding it is the one that controls that. So in essence, they can convert it to a form of a payable on demand, right? Saying, I'm extending, but only to this date, or I'm extending and then I demand that you make payment, right? That's fine. This works. What doesn't work, though, is potentially things like this, right? I promise to pay $10,000, payable the year after my lawn mowing business becomes profitable. So again, remember, could you do this? It's fine. Is it negotiable? No, it would not fall under Article 3. It would not be a negotiable instrument. Because why? How would anyone know when that is? When Bob's lawn mowing business becomes profitable. There's no way to know. And so for that reason, it doesn't satisfy that requirement to make it negotiable. It's not payable at a definite time, and it's not payable on demand. It doesn't work for purposes of a negotiable instrument. What about this? I promise to pay $10,000. Payable June 1, 2023, but I, the maker of this note, may extend the date of payment in my discretion, Bob. This is different than the other one. You might be like, well, didn't you just say, Tracy, that one like this was okay? And the answer is no, I did not. In the previous one that was okay, it was the holder, the party currently holding the note, that had the ability to extend the deadline for the maker to pay if they wanted to. Here, it's the maker himself, Bob, that's saying, I can extend the date of payment. Well, then you have that's not even a promise, right? That's illusory. That's illusory. He's not committing to pay ever, right? He's saying, I promise to pay on June 1, 2023, but I can extend this forever in my own discretion. That's illusory. It's not payable at a definite time, and it's not payable on demand. It doesn't work. It's an illusory promise. It doesn't work, and so it would not be a negotiable instrument. So what about this last requirement, that it's payable to bearer or to order? What we mean by that is that when we're talking about a negotiable instrument, there are three possibilities. That it's payable to bearer, meaning to whoever is holding the note or holding the check, right? That's saying it's payable to the bearer of the instrument. That's the kind of language you would see. The bearer of this instrument, whoever shows up with this thing, or payable to cash, right? Meaning it's payable to who? Whoever has it, right? Whoever has the instrument. So that's okay under Article 3. Payable to cash, you see people do that. So you could do that with something like a check, you pay to cash or whatever. That makes it a bearer instrument, right? Whoever's bearing it is the one to whom payment should be made, right? It's payable to bearer of any of those things. So that's what payable to bearer means. Payable to order, well, what does that mean? It means to the order of somebody, but it means two different things. When we say payable to the order of, and when we're talking about a note in particular, we need this language in order for it to be negotiable under Article 3. It's got to be, I promise to pay $10,000 to the order of Herman, because that means it either to Herman or to somebody that he orders payment to be made, right? That's what to the order of Herman, meaning whatever he directs, whatever he orders, to the order of the bank, right? So whatever the bank directs to the bank or to whoever, or payment to whoever the bank directs you to make payment. And so if you think about Barb and Bob giving the promissory note, the $10,000 promissory note to Barb for the Honda Fit, it needs to have said something like payable to the order of Barb, because then it's negotiable, right? Because when she sells that note to the bank, she's now saying, I am ordering, it is now Barb's order that money be paid to the bank, right? It's now being paid to the order of Barb, which is her order is paid to the bank. So that works. Then this is something to know, which is you could have something that just has a personal promise. Generally, if it's just a note with a personal promise, it's not negotiable. And again, it's vital you understand when we say non-negotiable, we mean it doesn't fall under UCC Article 3. We mean it would just be subject to ordinary contract law. So here, if it's just said, I promise to pay Herman $10,000, that's not a negotiable instrument, because the note would need to say what we just said under number 2. I promise to pay to the order of Herman, to the order of Herman. And in this case, the language is magical. It needs to say to the order of Herman $10,000. However, and this is why you might say, why do you keep saying with a note? Because if it's a draft, if it's a check, then you don't need to worry about it. It's okay. With a check, if it does contain just a personal promise, that's okay. That draft is still negotiable. It's still negotiable. So it's an exception. You want it with number 3 here, you want to differentiate between notes and drafts. Otherwise, the rules are the same. The rules are the same. So those are what we mean then when we're talking about payable to bearer or to order. So those are the requirements of negotiability. And again, keep in mind, every single one of those things must be met in order for that instrument to qualify as being negotiable, meaning that it's subject to Article 3 and that it then has the potential of being someone being able to collect on that instrument free of any sort of problem from whatever occurred in the underlying transaction, right? And we don't have to worry about what Bob and Barb, what occurred in their underlying contract. We don't have to worry about that because this is a negotiable instrument, and God willing, the bank's a holder in due course. But we'll talk about that. So we're focused on something very specific. So that's the first part there. I hope this lesson was helpful. As always, if it was, please like, please subscribe, and I appreciate your support, and I'll be back soon with another one.